Good afternoon or good morning, everyone. Thanks for joining us. This is Top 5 Employment Challenges in 2023 for government contractors. Can you believe it's already 2023? Here we are. I'm Sarah Nash. I am a partner in the firm's labor and employment practice. We deal with a number of typical traditional labor and employment matters, anything from Title VII classifications to FLSA questions, and then a lot of our industry focuses on government contracting, which is why we're here today. And so we also deal with a lot of the questions we'll talk about today, as well as standard prevailing wage issues that might impact a lot of folks on the call, and some of those more traditional questions like labor and employment agreements or non-compete questions. And we'll also talk about some of that today because it turns out there are a lot of meaty topics that are coming up on the horizon. Hopefully you all find it interesting. I welcome questions. Please feel free to ask them as we go along, and to the extent that I don't have an opportunity to necessarily get to all of your questions, I will do my best to reach out afterwards and connect if you have some lingering thoughts that you'd like to hash out. If you're not familiar with our firm, we're PilieroMazza. We're a full-service law firm that provides a range of strategic services to government contractors and commercial businesses alike. We have, as you can see, a number of focuses. Some of our primary practice groups are, of course, labor and employment. We have government contracts, litigation and dispute resolution, and then business and transactions. So without further ado, let's dive in because we have a lot to cover over the next hour. And we're just going to talk about, as the title suggests, top 5 considerations that are coming up that you just want to keep an eye out if you're in the government contractor space and are specifically focused on those labor and employment issues. I do want to mention that this presentation is cleared for HCRI credit. I will be providing the code at the end of the webinar. I will not forget. This is me telling myself I will not forget to provide that code. It has been approved, though, for 1 hour of credit. So thank you for joining us. And without further ado, let's get going. So most of this is going to be going over some of the things that folks already know and just some minor tweaks that might come up in 2023 or some minor changes that are really worth keeping an eye out for. We're going to talk about some of the trends in state law as well as some broader national changes that are coming down the pike. Some of these changes have been in place for the last couple months, and some are anticipated to come. And so we'll discuss how federal contractors specifically can comply with these new changes and avoid any potential pitfalls that might pop up as they're going through the motions. We're also going to talk a little bit about how to think strategically when bidding for new contracts and making sure that you are winning those recompetes. Just talk about some of those strategies that might help you keep ahead of some of these changes to help, the bottom line. And then lastly, just avoiding some of those costly mistakes that if you focus on them now could potentially save a lot of headaches down the road. So the first issue, and we have 5 big ones that we're going to talk about, mostly because if we had more than 5, I'd keep you here all day. But these 5 are probably the ones you want to keep your eye out on. I'm not saying that they're the only changes, but they are the ones that could have the biggest impact on the company. The first issue deals with employee classifications. And the overall rubric that we're looking at when we're evaluating these types of employee classifications is going to be the FLSA, that's the Fair Labor Standards Act. And that generally requires that companies pay minimum wage for all hours worked and for overtime for hours worked over 40 in a work week. And that is going to be unless employees are exempt. I'm going to talk a little bit about the difference between exempt employees and non-exempt employees. If you're listening in from the HR kind of perspective, of course you already know this. if there are some folks on the line who might not be as well versed in sort of those types of classifications, I will go over the difference. But generally, when you have a non-exempt employee, that's someone who's paid that hourly wage typically, who is not working as a salaried employee, they are entitled to at least $7.25 per hour in the US. That's the current minimum wage for such employees. It varies by state, and it especially varies by government contractors. So as folks likely already know, there is also a requirement for federal contractors to pay their workforce at least, and this is where it varies a little bit, either $12.15 or $16.20 per hour. There was last year an executive order 14026 increased the amount of the minimum wage paid to federal contractors. I will talk in more depth on a later slide because that's actually one of our main topics today. But suffice it to say that government contractors are held to a higher standard, just like a lot of states hold their companies to a higher standard. You know, places like California, Maryland, DC all have higher minimum wages than the $7.25, and that's always something to keep an eye out for. The FLSA is generally administered by the Wage and Hour Division of the U.S. Department of Labor. Folks on the line might also be familiar with some of the other laws in government contracting that Wage and Hour is responsible for enforcing: Service Contract Act, Davis-Bacon Act. They are often in the weeds on those issues that deal with, as you can imagine, you know, how employees are paid, what benefits employees are earning. So before we jump into some of the anticipated changes over the next year, it's important to keep in mind how you classify employees. And one of the reasons is because DOL is looking at increasing sort of the difficulty of classifying someone as non-exempt, which means that we could be seeing a change later this spring, maybe summer, depending on when Wage and Hour gets their ducks in a row, but they're looking to increase sort of the salary basis threshold, which could end up in a domino effect impacting a lot of other operations. And so generally, if employees are going to be properly classified as non-exempt, that means they're not exempt from that minimum wage requirement and the overtime requirement. They need to, if they're going to be, classified as exempt from those requirements, they need to meet two specific tests. One of those tests is a salary basis test, and then the other test is a duties test. Currently, that salary basis test requires that employees are paid at least $684 per week on a salary basis. Essentially, that's meaning that an employee must regularly earn the same salary week to week. There's actually a Supreme Court case that came out just this morning that was answering this very question related to highly compensated employees. In that case, and sorry to get a little legal on everyone, but it just came out, it's all very exciting. A employee earned $200,000 a year, but instead of being paid on a weekly basis, he was paid on a daily basis. So each day he earned the same rate. If he worked one day, he earned, you know, a certain amount. If he earned 2 days, he earned twice that amount. So it's based on his daily rate. Ultimately, the Supreme Court determined that it didn't matter that he was so highly compensated. He still needed to meet that salary basis test, which required that he be paid the same amount each week in order to satisfy that test. And so if some of you have employees out there who are maybe not earning, you're like, oh, well, they're really advanced. They have very executive duties. They're in charge of how these operations run. It's very important. That none of that really matters if they're not paid in this salary basis. So you cannot make deductions for partial work days where they're not working. There is an exception if employees are taking a full day for personal reasons, or if you are making a full day exemption for discipline. Suppose that they've been disciplined, you know, suspended without pay for 2 days. You don't have to pay them in those instances, but otherwise there are very strict rules And if employees are generally ready, willing, and able to work, then they must be paid as salary employees. Otherwise, they lose the exemption and they're required to be paid as hourly non-exempt employees. Mouthful. In any case, these are the two tests that are very important. DOL is looking at raising that salary basis threshold. Currently, it's $684 per week. That equates to about $35,500 a year. If you have folks who are earning less than that amount, they must be classified necessarily as non-exempt. DOL, again, is looking at raising that rate. So this might be a good time to look over your exemptions and get a sense of where employees are falling, where they're classified. DOL is also revving up their enforcement mechanisms. As I said, they're responsible for enforcing these FLSA requirements, and that means that they are going to be conducting audits, making sure that folks are properly classified. It's a good idea to have records of how you classified your folks, how they're being paid, and what their duties are to make sure that they are properly classified. And so that kind of gives you the background of the salary basis test. There's also this duties test. Generally, there are three main categories that employees can be classified as exempt under the duties test. There's going to be an executive exemption, an administrative exemption, and a professional exemption. I'm not going to get into the details of those, but again, it's a good idea. You do have folks who are maybe on the threshold, maybe in that $35,000 range of salary, take a closer look and see whether they are properly classified and will remain properly classified if DOL does proceed with increasing that salary basis threshold. It's anticipated that there will be a legal challenge if they do increase that amount. Jury's out as to what that future looks like. Specific to government contractors, there are some really important things to keep in mind when you're looking at these classifications. First, you need to keep in mind that accounting for government contractors and those responsibilities are not the same as the responsibilities that you owe to employees. Often we'll hear clients or companies say, well, my contract doesn't allow for overtime, so I can't possibly pay employees overtime. I mean, you're not wrong. However, that does not erase the obligation to pay non-exempt employees at that hourly overtime rate. And so the important thing is that you're carefully tracking the hours that they're working. If there is an instance where an employee works more than 40 hours a week, the response is never, well, our contract doesn't allow for it, so we're not going to pay you. The response is, our contract doesn't allow for this. This was not authorized. You needed to get advance approval to work these additional hours. We will pay you for the time you worked. However, if it happens in the future, you may be subject to discipline. And so essentially progressive discipline. Discipline is always the answer, but also make sure that you're paying them. I should mention that we talk a little bit about this in future slides. There are some differences across state lines. So for example, in California, there is a higher salary basis threshold than the federal standard. Same goes for New York and a few other states. So you always want to make sure that you are staying ahead of whatever state, federal, or local laws might additionally put some restrictions on how you're organizing your workforce. Common additional concerns that come up in this timekeeping sort of framework include exempted employees that look like hourly employees. Again, it's going to come down to what you're making those deductions for. Often, this will come up in the case of a government shutdown. And I'm hoping that Congress gets its act together this year and we're not looking at any shutdowns in the near term, but it has come up recently as a potential consideration. In the event of a shutdown, technically that's not an employee's decision not to work, that's the company's instruction not to work, which means that if you have a partial week shutdown, technically salaried employees should be paid for that full salary for the week. Now, you can supplement that with PTO or other forms of paid leave, or sometimes you can provide in advance, but you do have to continue paying them their salary for the week. That rule goes out the window if you have a full week shutdown. If there's no work performed in the week, then there's no obligation to comply. But if you have, for example, maybe Tuesday there's a shutdown, you still have to make sure you pay your workforce. This is all so you can avoid retroactively DOL coming and saying that someone should have been classified as non-exempt, meaning that they were entitled to overtime. Of course, if employees are never working 40 hours a week, more than 40 hours a week, and you know that they're never working 40 hours a week, the risk of having employees lose that exemption is not particularly high. This really will be a burden, though, if it turns out that they've been working 60-hour work weeks, and all of a sudden that time that was initially captured in their salary now needs to be paid at time and a half. Can create a lot of headaches, as you can imagine. Another issue that you often deal with in this space is, your employees are working side by side with federal personnel, and often federal personnel don't necessarily understand the employment requirements. And so if you have a customer that tells your employees, or if you have a PM that tells your employees not to put overtime on time cards, that can be an issue. So that just means you want to make sure that you're looking carefully at your handbook policies, making clear to your PMs, to your employees, that every single minute of time, especially for those non-exempt, again, those hourly similar work employees, that they need to be marking their time down. There's a separate type of classification issue that comes up in the context of independent contractors. Sometimes folks will refer to their 1099 employees. That is kind of a myth. When you are 1099, you are not technically a company employee. You are an independent contractor. And there are a number of states who are moving towards sort of how California has approached this. It's referred to as an ABC test, where if employees or independent contractors are performing in the same type of industry, the same type of space as the company that's engaging them, often they will be considered employees. And it can sort of undo the independent contractor relationship. As you can imagine, this presents a series of problems because it can suddenly subject companies to additional taxes, workers' comp considerations. There's a number, all of those obligations that you have to pay employees for certain taxes and deductions, those could suddenly be applied to independent contractors. So it's important to keep an eye out for state-specific requirements. In the independent contractor context of government contracting, also remember that when you have an independent contractor, they are considered a subcontractor if they're working on your government contract. That means that you are obligated technically to flow down those FAR clauses and make sure that you're including the required representations and warranties. It's just really important that you flow down those obligations in the event that there is an audit down the road, because you want to make sure that the independent contractor knows specifically what their obligations are as well. There are a couple of prevailing wage considerations. Remember, under the FCA, they apply labor classifications regardless of contractual relationship. And so independent contractors are often subject to prevailing wage requirements if they are performing SCA type work. So just keep that in mind. It's not sufficient to just say, oh, they're an independent contractor, I don't have to worry about my SCA obligations. You always want to make sure that you're complying with those requirements. Lastly, the questions, there's sort of a multi-factor test that DOL and the IRS use to evaluate whether someone is properly classified as an independent contractor. It's a series of factors. Generally, you want to make sure that you have a very clear consulting agreement between you and the employee, even better if they have their own LLC. You want to make sure that they are paid a little bit different from your workforce. You don't want them to be paid, just on the regular payroll. Ideally, they will be submitting invoices. There are just a few things you can do to really emphasize that independent contractor relationship. And we've seen DOL recently sort of cracking down on some of those questions, especially where you have a disgruntled independent contractor who is not particularly happy with the way things ended. You might find that next thing you know, they've gone to DOL, filed a complaint, which can sort of lead to, an unpleasant audit down the road. So those are the classification issues. Again, DOL is looking at changing the salary basis threshold, which could lead to a cascading sort of outcome of how contractors are classifying their folks. This, in turn, can impact your SCA classifications, your DBA classifications. So it's just important to keep ahead of that. And we anticipate DOL is going to be cracking down on some of these issues. So always a good idea to do a self-audit, make sure that you have a good sense of what your folks are performing, how they're paid, and make sure that everything is looking accurate. This brings us, and I already touched on it briefly, to the new minimum wage requirements. By now, they're not particularly new. Folks probably heard that last year, President Biden issued a new EO 14026, which establishes a minimum wage for contractors. For those who have been in the game for a long time, you're probably already familiar with the prior minimum wage for government contractors that was set by the Obama administration. The thing that makes this a little bit more complicated is now we have two EOs just out there floating around. By now, most contracts should have the new executive order incorporated, but the FAR Council, in all their infinite wisdom, decided to give both of these EOs the same FAR clause number. And so that means that it's not always clear which FAR clause has been incorporated into your contract. So the magic words that you want to look for are that EO 14026 to make sure that this is the newest one that's been incorporated as opposed to the earlier one. Some contracting officers have taken the position, it's one and the same. As long as you get that in writing, that they are considering that the new rate applies, that's fine. But you do want to make sure, for purposes of receiving a price adjustment, that the new rate has been incorporated before you go ahead and give people proactive increases. On January 1st, 2023, the new rate went up to $16.20. That change is automatic. It does not require a specific change from your CO or from the agency. As long as that a minimum order FAR clause is in your contract, that means that you are obligated to pay anyone who's working on or in connection with that federal contract at least $16.20. Previously, it was $15. It's going up at a fast click, and it applies to pretty much any contract entered into by the federal government pursuant to, those standard procurement requirements. I mentioned earlier that it applies to anyone who's working on or in connection with a federal government contract. That generally is going to apply to, obviously, the folks who are working specifically on the contract. So the folks who are performing the work covered by the government contract, they are covered by the requirement. If you have payroll folks or HR folks who are working in connection with that contract, in other words, the work that those individuals are performing is necessary to the federal contract, they also are covered by that new minimum wage. Previously, this wasn't a big deal that came up that often, but as you can imagine, $16.20 an hour is pretty high. It is higher than a lot of state requirements. It is even higher than a lot of SCA requirements. And so for the first time, we are seeing a lot of changes hit on that January 1 date. So it's important that on January 1, everyone increased their rates to $16.20. If you didn't, go back and do it now. Of course, assuming that FAR clause has been incorporated into your contracts. There are also notice posting requirements to be aware of. You want to make sure that folks are aware of the new increases. And then keep in mind wage compression issues. I mentioned that this minimum wage is higher than a lot of the SCA wage rates out there. As you raise those wages, you might run into a situation where your managers are not necessarily impacted by the increase itself, but where they're suddenly not earning the same higher rate that they were earning before. So for example, if you had a manager who was previously at $16.50 or $17 an hour, suddenly maybe you need to rethink how you're actually compensating them, because you want to make sure that you are compensating them for the work that they're performing. And unfortunately, when you do those sort of voluntary increases, those are not covered by a price adjustment. So just keep that in mind as you're evaluating your bottom line. So we've covered the first two, labor classifications and minimum wage requirements. This third one is a little bit different. It focuses on some of those recruiting and retention practices. And there have been some changes in recent years, especially in light of COVID, that are just worth focusing on. I'll talk a little bit about those pre-employment considerations, a little bit about the post-employment considerations, and sort of what companies are thinking about as they're trying to attract and retain talent. Because I don't think we're at the same place we were last year, where, you know, there was the great resignation going on and lots of people were leaving, and I think it slowed down a little bit, but there are still some considerations, especially in the government contracting space, that are worth keeping an eye out for. So with respect to pre-employment considerations, there are a number of caveats or conditions that folks can place on employees or applicants when they're providing an offer letter. One of those considerations is going to be whether or not you require background screening. That background screening can include a number of questions about criminal background. It can include questions about educational background, credit background in some instances. And so generally, if you have this type of screening, which is not a bad idea, you will have a third party administering the screening to evaluate what's out there to make sure that this candidate is a good fit for the job. You always want to make sure that you provide the candidate with the appropriate notice for that background screening. Under the Fair Credit Reporting Act, there's an obligation where you are essentially having a third party perform the screening to make sure that folks are properly authorizing the background screening. So just make sure that you're checking all those FCRA requirements. You also want to keep in mind that many states, including now a requirement for government contractors, include a ban the box requirement. This means that while you can ask about an individual's criminal background, you can't do it before you've made a tentative offer of employment. So this is not asking about criminal background, asking about the histories there should not be coming up in the initial interview. It only comes up after folks have gotten that initial conditional offer. We've also received quite a few questions recently about, you know, this popped up in this individual's background. What should we do? It kind of turns on a number of factors. So if someone has been convicted of a crime, there are a number of factors that, strangely, this is something that kind of falls under the purview of the Equal Employment Opportunity Commission. The reason for that is because they want to make sure that there's no disparity in how we're looking at folks' background testing. And some individuals of certain races could be unfairly disadvantaged by looking at this criminal background. And so there's sort of this range of factors that are considered when you're looking at an individual's criminal history. And that involves how long ago the transgression happened, whether it's related to the duties that they're performing, the severity of the crime. There's just a number of considerations that may or may not be reason to revoke an offer. So you just want to make sure that you're thinking through those considerations if you do have someone pop up in a background screening. You know, sometimes if you're working on a certain type of contract, the government's background sort of requirements will take care of that question for you. But especially in government contracting, you know, you don't want to waste your time on an applicant if you're trying to fill positions. And so sometimes, while it would be nice to wait for the government's decision, you don't always have that luxury. So it's important to keep in mind some of those restraints on how you respond to criminal histories. Another big issue that's especially been percolating over the last few years, and we talk about it on a later slide, is this drug testing issue. So under the Drug-Free Workplace Act, companies have an obligation to ensure that there's no drug use on the contract or on the government space while employees are performing work, right? And so there are also many contracts out there that actually require drug testing. But technically, under the Drug-Free Workplace, there's no requirement to do drug testing. It can sometimes be a company-by-company decision. Again, if you have a contract that specifically requires that your employees are drug testing, that's sort of a different story. But generally, the question's been popping up, especially in the context of medical and recreational marijuana, where states are legalizing marijuana. How are companies responding to marijuana use and whether employees are testing positive for marijuana use? One of the slides later on, we talk about multi-jurisdictional issues. That's a big question that's popping up. How are we dealing with drug testing? And so this is also a consideration. As you're working through your drug testing, how are you evaluating whether you use drug testing or not? Again, if your federal contract requires it, it's not really up to you on whether you're going to require it of your folks and your applicants. But one question for individuals is whether you're going to continue using this drug testing. We've been seeing a lot of companies move away from it, especially as it relates to medical or recreational marijuana. And then finally, one change that specifically is occurring in the prevailing wage world is that the Service Contract Act is revisiting non-displacement obligations. So last year, I think it was last year, maybe at this point it might have been 2 years ago, Biden issued an executive order that reinstated non-displacement of Service Contract Act workers. This essentially means that when you are a successor SCA contractor, you will eventually, the requirement is not in place yet, but you will eventually have an obligation to hire, and everyone, I apologize. I have been just talking here happily, and everybody's been asking these great questions, and I've just been ignoring them. That was not intentional. I just didn't open my question box. But just keep in mind that this non-displacement rule is coming back. It was previously under the Obama administration. It was revoked by the Trump administration. Now it's back under the Biden administration. One can only imagine what will happen in the future. But DOL is set to issue final regs in the coming months. I've been saying that for a while, but you know, they're at their own pace. They're set to issue those regulations in the coming months, weeks, hopefully, and so we should see them popping up. And just, it's very important to make sure that you're complying with those requirements. There are obligations such as providing incumbent SCA employees with at least 10 days written or offer of, like an offer of employment that's open for at least 10 days. And so there are some restrictions on how you're doing the work, so you just want to make sure that you're complying with those obligations. I'm going to take a pause here and just get to some of these questions before I'm completely far away from everyone. The first question we have is, do independent contractors receive paid sick leave and paid holidays if working on an SCA contract? Great question. I almost touched on it, and then I said, I don't know, is this something that people want to hear about? But thank you for asking this question. So it is sort of complicated with independent contractors. What I typically recommend is, if you do have an independent contractor who's performing SCA work, you would not provide them with sick leave and paid holidays. What you would do instead is essentially calculate a rate that is owed to them based on what they would be paid. So rather than paying them, rather than giving them the day off, you just say, based on the Service Contract Act requirements, we're providing you with an additional, $200 for this holiday that's incorporated in the wage determination. Same goes for sick leave, same goes for vacation to the extent that they're performing work for more than a year, and those other types of benefits that would really be employee specific. Another question is, this says not to incorporate the new minimum wage until it is, the $16.20 until it is written in the contract. Is it not automatic effective January 1? So I just want to make sure that I'm clear on this. So as long as the appropriate FAR clause has been incorporated into your contract, the $16.20 is automatic. However, if that FAR clause has not been incorporated into your contract, and again, it should have been incorporated at your last option year sometime since January 2022, but if it was not, that's where you need to put the brakes on and just wait and see if it's been incorporated into your contract, or talk to your CO and figure out why it hasn't been incorporated in. But otherwise, as long as that FAR clause is in there, 1620 is automatic. Let's see, what else do we have? There's another question that relates to, have the new minimum weights been incorporated into the SCA rates? Also a great question. There is a reference in the wage determinations to the minimum wage requirements, but it's not great. And I think what DOL was trying to do was essentially say, this minimum wage requirement is automatic, but that's inconsistent with the way the regs are read. And unfortunately, you still have a lot of SCA wage determinations that are lower than 1620. That's because the DOL, the way that they put together the prevailing wage calculations, it hasn't had a chance to catch up yet. They're still a few months behind. And so you might see a SCA wage determination that has a $15 an hour minimum wage requirement, whereas we know that the 1620 is the current federal contractor minimum wage requirement. You have an obligation to pay the higher of the two. So just because your SCA wage determination says that employees are owed $15, that's not sufficient. You have to comply with the 1620, and further, you have to comply with any state-specific or locality-specific requirements that might be even higher than that $16.20. And so it is just important, again, that you're looking at your contract. You want to make sure that the minimum wage FAR clause has been incorporated, the one that's specific to that new EO, and you want to make sure that those new wage determinations have been incorporated into your contract. Another question is, if a security clearance is required for the job, what then? So if you have a background check and you require a security clearance, generally you're going to go through that security clearance process. I will say that there are a lot of rules, special rules that apply to security clearances. And this is where a lot of those state legalizing marijuana questions kind of dissolve, because if you have a security clearance that requires drug testing, that specifically requires medical or marijuana testing, you have an obligation to test your folks. Most states, with a couple exceptions that are really quirky, like Montana. Montana has a really weird legalization policy, but most other states do have an exception where you have a security clearance contract or a federal contract that requires testing. There is an exception to their rules against marijuana testing. Another question about, can you speak more about the notice of the background check? Is there a certain amount of time or type of language that needs to go out? Yes, there is. So under the FCRA requirements, you do have an obligation, assuming that you have a third party running your test and your screening, to provide them with specific Fair Credit Reporting Act notice requirements and authorizations. If you have a third party running your check, the hope is that they provided you with that paperwork and they've already got it set. If for some reason you're running background checks through a third party and folks aren't signing off of some authorization form, that's a red flag, and I would recommend that you dig a little bit deeper and try to figure out what might be missing here, I'm happy to jump on a call to talk about it. There are some state-specific requirements too, so again, it could depend on where you're performing the work, but regardless, those federal requirements under FCRA are going to apply. Just a couple more questions, and then I'll proceed with talking about some of these recruitment issues. So this is the question. Have you ever been, I guess a question that's asked on a company's background check. Have you ever been charged with or convicted of any felony or misdemeanor, including but not limited to assault, sexual and drug abuse, which has been expunged, dismissed, or sealed? Do we have to remove this question? If it's before you're actually sending out offers of employment, that's not generally a question you want to ask. There might be an exception if for some reason you have a contractual requirement not to hire someone who's been convicted of a felony or a misdemeanor, but otherwise, I'd want to take a closer look at that, because that could present an issue with the ban the box requirements. As I mentioned, those are applied at the federal level now for federal contractors, so it's important that you stay ahead of that. You might want to revisit that language. And then just a couple more questions, although this is a good thing, I think, that people have questions, because it's keeping things interesting. The list keeps on getting longer. But here we go. If we don't receive an updated WD for one of our SCA contracts, despite numerous requests sent to our CO, should we pay the hourly rate and H&W based on the latest wage determination? So the answer to that question, and this is really getting into the weeds of SCA, but the answer to that question really depends on whether you would like a price adjustment for the increase. The SCA is a floor, not a ceiling, which means that you can pay more than the SCA requires at any point. The caveat there is that if you do pay more, you're not necessarily entitled to an adjustment for that increase. If you wait until the new WD has been incorporated into your contract, then you get an adjustment, assuming that the contract was bid correctly and you don't necessarily have other escalations in there. But the problem with paying before the CO has incorporated it is that you might not get an adjustment for the increase. Again, you don't have an obligation to pay that increase either. I can understand, though, especially from a recruitment perspective or a retention perspective, employees are more likely to stay with you if they have a higher wage rate or a higher H&W rate, right? And just to remind everyone, that new wage determination is only supposed to be incorporated at each option year. So folks might know that every summer DOL comes out with a new H&W rate. Just because they're issuing that new rate, or just because they're putting out new wage determinations, doesn't mean it automatically applies to employees or needs to be incorporated at that minute, but it does need to be incorporated at each option year. And that's where the CO's obligation comes into play. If you're having trouble with the CEO who's really just not familiar with those requirements, you could try sending them the FAR clauses that include the requirements. Another sort of nuclear approach is to reach out to DOL, but I'd be hesitant to do that, because that means that they'll probably initiate an audit, and no one wants an audit. But there are some tools in your toolbox, and if you would like to hop on a call after this, we can talk through some strategies that you might want to implement. Only a couple more questions. FMCSA DOT, great one in the drug testing context, requires drug testing in all states. How does this affect contractors that have to run FMCSA authority for service trucks? So again, if there is a drug testing requirement under your contract, especially when you have those safety sensitive positions, so when you have truck drivers, there's a good reason for why you would need to have a drug test, would want a drug test, and would want random testing. Sometimes contracts, especially DOE contracts, might include random testing requirements. That often will require drug testing in those contexts. Generally, that requirement is going to impact directly how you're, onboarding your workforce, what types of drug testing you have. You want to have a very clear drug testing policy that goes over the circumstances, whether it's pre-employment drug testing or reasonable suspicion drug testing. Just want to make sure that you make those rules very clear, not only so you comply with those drug testing requirements, but any state requirements too, because a lot of states have different rules for how you roll out those drug testing policies. And then lastly, we've got a question about, can you run a credit check on all employees? Is it legal to do it on all or only specific jobs? Generally, you can run a credit check on your employees, but there is a caveat in that there are additional rules that apply when you're running a credit check, and so you want to just make sure that you're keeping ahead of those. And so I'm not going to say you can't do it on your folks, but it is smart to do it, you know, in those finance, payroll, cybersecurity examples, or where you have to have folks go through a security clearance. You can imagine why a security clearance and someone's credit could really be intertwined. And of course, those are questions that are going to be asked on the security clearance anyway. And I think that rounds it out. I do think we are sending out copies of the presentation, or it will be available online, but I'll double check. I don't actually have that's above my pay grade at this point, but we will get you an answer on that. Okay, so jumping back into employment agreements, I'm going to go through this just a little bit quickly because I think a lot of it is stuff you already know. This just relates to, do you want to give employment agreements to your workforce? And I should mention this caveat that employment agreements really include a broad spectrum of agreements. It's not just going to be those. Often when folks think of employment agreements, you think of, you know, an employment agreement for a term of years, or this is your compensation. That's not generally 95% of the time what we're talking about when we refer to employment agreements. Often we're also just talking about NDAs, non-competition agreements, duty of loyalty. And so there are some terms of employment that you can include in an employment agreement that don't necessarily run the full gamut of, you know, executive compensation that you might think of. Those sort of bells and whistles of executive compensation do come in handy, especially when you have high-level executives, you're trying to retain talent. There are some really neat things you can do with, you know, retention bonuses and equity plans and stock ownership that could create a really nice compensation package. But generally, if you're looking at employment agreements, you can also just be looking at standard, you know, protections for the company and mutual understanding between employees and the company on what types of expectations there are. And so generally, when you're an employer, you're going to be looking at what are we worried about, right? We're worried about retention. We're worried about making sure that if someone is terminated, it's not adversely impacting the company. And we're worried about that post-employment world of non-competes, non-solicitations, non-disclosure requirements. What are employees going to be doing afterwards that could impact the company? And whenever you're looking at employment agreements, you have to also look at what employees are interested in. They're going to be looking at compensation. They're going to be looking at whether their employment is secure. More recently, with COVID, we've seen folks wanting to know whether they have remote work opportunities, whether there's a hybrid opportunity, what the telework options look like. There are some ways that you can really attract talent that don't necessarily cost the company much, assuming, again, that your government contract allows for some remote work. And then lastly, employees are going to want some rights and flexibility in their post-employment. So if it's coming down to whether they're going to be restricted through a non-compete for 3 years after employment, that could inhibit their ability or their desire to join in. We've seen a few more questions come in. I'll try addressing them quickly just to keep ahead of it. What can we check to see if employees will pass the government public trust background check? Oh, that is a great question. And I wish I knew the answer. It's sort of like reading tea leaves at a certain point. There are some regulations out there, some guidance that talks about what the public trust background check considers. Generally, what I would recommend is if you do want to try to get ahead of that, and there is sort of some legal risk involved, right? Because if you reject someone based on something that pops up in their background history, often you'll have an obligation to advise them of the reason that you've rejected them from the hiring process. It's possible that they disagree with your decision, which could lead to sort of some legal. I'm a lawyer though, so I'm always looking at this stuff from a risk-adverse position, and probably a lot of you out there are, entrepreneurs and business owners and, folks who have sort of a different approach to risk. But my risk aversion is put the burden on the customer, not necessarily the company. Of course, you can't always do that, and you need to get ahead of it in some time. So there aren't necessarily clear rules, but sometimes you can get a sense of what the public trust requires or some history of which types of employees have been rejected in the past that can help inform that decision. From the company's perspective, you just want to make sure that you're not making the decision based on, for example, a criminal record of a misdemeanor that happened 10 years ago that's completely unrelated to the position. That generally is not going to be the type of thing that you want to use in your evaluation, although if the government does it, that's sort of a different question. Another question is, if you have multiple offices in different states, is drug testing policy governed by the state which the company is incorporated in, or do you have to have multiple policies for each office in different states? Excellent question. Unfortunately, the rule is the law applies of the state where the work is being performed. So if you have employees in Mississippi, Mississippi law applies. If you have employees in California, California law applies. And really, it rarely matters where the state is incorporated. Ultimately, it's going to be where the work's being performed. And we've got a few slides on multi-jurisdictional state laws that are changing that we can kind of jump into that a little bit further. And then we have another question. Are you seeing many government contractors offering unlimited PTO? That has been more popular recently. Seen a lot of folks implementing policies. There are a few places where it can be complicated. You've got some states like Illinois. Illinois is actually a really quirky one. Illinois is one of the few states that actually has a requirement, even if you provide unlimited PTO, to pay out PTO upon termination of employment. There are some quirky rules there. But assuming that you're not operating in one of the quirky states, it's a lot easier to implement a PTO unlimited policy. Generally, for states like California and some others, you just need to make sure that it actually is unlimited. You can set performance metrics and requirements, but if you are placing a limit on what employees can use as opposed to what they're approved for, and I'm not going to get into the weeds of that, but you could ultimately be found to have provided a certain amount and have to pay that out. And often the reason for the unlimited PTO is to avoid paying that out. So in those unique circumstances, it can be a little bit of a headache, but otherwise, we are seeing a lot of companies move towards that. We're also seeing companies move towards PTO generally, as opposed to vacation and sick leave separately. You have one bucket of PTO versus two buckets of vacation versus sick leave. That does not work in the FCA context. So if you have FCA employees, I would not, it's kind of impossible to do the PTO approach. The other issue, it can be a little bit complicated, is when there are sick leave requirements based on state law, in which case some states require carryover that can kind of interfere with having a PTO policy. So that's just another consideration to keep in mind. Regarding work location, how is this affected by remote workers? For example, if a contract is based in Washington, D.C., but the remote worker lives in Illinois, which location applies? So it's going to be the location where the worker is performing the work. This is different from sort of an adjacent question of, like, where do I need to be registered to do business? Most states do not require you to register to do business if you just have a handful of employees who happen to be remotely performing work in the state, but the impact of the work is actually felt, in Washington, D.C. That's not every state, but that is most states. But when it comes to employment laws and employment taxes and those requirements, I'm going to say I can't think of a single example where the state of employment doesn't control how the employee is paid. or the benefits they receive. So that's generally, where the work is performed, that's the state law that applies. Another question, I suspect we're going to get to it in the next couple slides, but let me, this is a little bit teaser on the subject, and I realize that we only have 5 more minutes, so I'm going to try to be snippy without jumping over the content. If a state allows for recreational marijuana, is the employee required to refrain from use when on a federal contract? Yes, absolutely. You cannot smoke or possess or use or be under the influence of marijuana or any other drug while you are performing work on a federal contract, while you are on a federal work site. I think that's pretty much it. So that is a rule that applies regardless. So if you have an employee who has a joint on the site, you don't have to terminate them. You can terminate them, but you certainly need to discipline them. How do you handle DC with the sick leave if you call it all PTO? Great question. I'm still trying to wrap my head around that one. We have yet to see DC enforce sort of this carryover requirement, but DC makes it really difficult. I'll talk a little bit about the different state laws that relate to sick leave. And DC just has a really complicated one that doesn't allow for caps on carryover, or I want to say use, or I think they allow for caps on accrual, but it just makes it really difficult to navigate. But generally, if you have a really generous PTO policy that it provides at least as much sick leave as state law requires, and it varies depending on your size of your business, you're going to be okay. But it is, if you're trying to keep, in line with the actual letter of the law, it's very difficult to combine PTO and sick leave together with DC. How do you pay out leave with an unlimited PTO? The idea of unlimited PTO is you don't generally need to pay out the leave. There are some caveats there, for example, and I know if you have work in Illinois, it's really difficult. I would need to look again at the regs because it's been a few months, but they essentially would look at the history of vacation that the employee took and calculate what the likely leave would have been in the past few years, and then figure out what you would have owed in this year. It's really convoluted. It doesn't make a lot of sense. Hopefully they're looking at changing that law. But yeah, generally they would find a way to say, well, this is what employees were actually earning in vacation. It wasn't unlimited. This was the limit. So I've got another question that I do want to clarify. So are you saying you cannot provide PTO? It has to be specifically labeled sick leave or vacation in government contracting? No, I apologize. That's not what I'm saying. Just in the Service Contract Act, which is a specific type of contract, where you have SCA employees who are performing work in support of an SCA contract, you cannot combine the two. The reason for that is because you have to pay out vacation, you have to carry over sick leave. It just doesn't work together. But in other contexts, perfectly fine to combine the two. Not a rule in government contracting. And then we've got one more question for on-call employees who live around the country and are asked to work a week or two in other locations. What state law applies? Generally, again, it's the state where the work is being performed. If folks are just in one or two places for, a couple weeks, chances are you're not going to run into issues. There's sort of a de minimis rule that goes hand in hand. There are some states that have very specific thresholds when taxes kick in, or when you owe, state taxes in that state based on where the work is performed. But generally, it's going to be at least, a month or two before those requirements apply. And just to round out our talk about recruitment considerations, it's not generally a one-size-fits-all. You want to think about the level of employee. Again, are they an executive officer, or are they rank and file? And that will often determine the type of requirements or rules or agreements that you might enter into them, the type of industry. In government contracting, generally you're going to have very narrowly tailored non-competes that relate specifically to your customer clientele. It's not going to be a mileage restriction, for example, for those types of restrictions. And just like how employees are exposed to sensitive information like trade secrets. If you have a janitor, maybe it's not as important that folks sign an NDA versus if you have people who are working with your proposals, working with your price pricing, you want to make sure that you have the right employments in place or agreements in place. And then you have to consider whether you want a simple letter or a formal agreement. We have 2 more sections, and I realize that we are cutting into folks. We're well past the hour now. But I'm going to try to touch on these. I understand if folks have to jump off, and if you want to, I know that the webinar will be made available afterwards. So if you can't listen in now, but you're interested in either pay equity evaluations or the managing state laws for multi-jurisdictional employers, I'm going to just go over them now, and I apologize that this was longer than an hour. I should have known. It's always the juicy stuff, you know, that gets the good questions. So bear with me. I'll try to get through this and not keep everyone too long. So pay equity evaluations. One of the big changes that came down from the OFCCP last year is that they are going to start requesting as part of their auditing employers' pay equity analysis. Now, there has always been a requirement under the regs that companies perform this pay equity analysis, but this is the first time that OFCCP is taking the position that they're entitled to see that analysis. As you can imagine, there can be some very sensitive information in evaluating how employees are paid based on their gender, their race, and their ethnicity. And so this is something that generally companies don't generally want to hand over to the OFCCP. There is sort of a way around providing this pay equity analysis, and that's to involve legal counsel in the process, because OFCCP has acknowledged that a pay equity analysis can be privileged under the attorney-to-client privilege if you have attorneys who are involved in that process. What does that mean practically? It means that companies can avoid providing their full pay equity analysis if it's privileged under attorney-client privilege. There was a second directive that OFCCP issued shortly after the first one that sort of clarified this whole question. And they went into a series of factors that they believe they're entitled to that will help them evaluate employee pay as they're looking through these questions. That information is summarized on this slide. And so if contractors have attorney-client privileged pay equity analysis, they can, as an alternative, provide essentially this list of information rather than providing their full pay equity analysis. This list can be provided in a few ways. They've confirmed that a contractor could essentially fill out an affidavit attesting to what this information was. They could redact certain parts of their pay equity analysis, or if they're feeling really ambitious, they could just conduct a whole new pay equity analysis that does not involve legal review. As you can see from these factors, there's very specific information they're looking for. Does not include the ultimate findings from the pay equity analysis, but enough essentially to confirm that the analysis was completed. There is some dispute over whether employees are actually, or OFCCP, is actually entitled to this information. After all, this is their directive. It is not actually included in the regulations that a contractor is obligated to provide this information to OFCCP. For that reason, we could see some legal challenges down the road, but we will see. And as of now, the OFC's position is that this is information that needs to be turned over. So reminder to everyone, you do need to be conducting that pay equity analysis. Another reminder that if you are conducting it, you should probably have legal counsel involved because that can attach a privilege that allows you to explain why you do not turn over the full analysis to the OFCCP when they ask for it. As you can imagine, again, there could be some findings in that analysis that you don't want to be made public. And then this brings us to the last of the big five, managing state laws for multi-jurisdictional employers. There are so many variations in law. We talked about Fair Credit Reporting Act changes, ban the box changes, but I focused on just the top three that we see, and I'm try to get through them in the next 5 minutes so that I don't keep folks too much longer. The first, and we've touched on this quite a bit throughout the webinar, is sick leave laws. There are so many states out there with different sick leave laws that require that employees are paid for sick leave. And generally, the amount of accrual varies, but it's going to oscillate between 1 hour for every 30 hours worked. It might be a little bit higher than that. Generally, you have some states that are a little bit lower, but somewhere in that ballpark. Important things to remember. Sick leave generally, I'm not actually familiar with any state sick leave laws that have an exception for part-time or temporary employees. So if your PTO policy, for example, carves out part-time or temporary employees, that is not going to satisfy the sick leave requirements in the states where you're operating. Again, it's going to be the states where those employees are performing the work, so where they're working from. Some states do have a minimum number of employees threshold, so you should always check to make sure if your company satisfies those requirements. Most of those requirements apply nationwide. So if they say you must have 15 employees, it's often not just 15 employees in the state, it's 15 employees across the country. There may be probationary periods that are allowed by the state sick leave laws, but often they're not permitted. So sometimes you might have a sick leave policy that says you don't begin accruing sick leave until you've been with the company for 90 days. That is generally disallowed under a lot of these state sick leave laws. So you just want to make sure that you're complying with whatever rule covers your workforce. There are also going to be caps on that might be permitted on use, accrual, and or carryover, but a lot of states don't permit caps on some of these things. So you always want to make sure if you have a cap on carryover at the end of the year, for example, make sure that that complies with your state sick leave requirements. Another issue relates to requesting doctor's notes. A lot of states put a limitation on this. You cannot require a doctor's note if an employee has been out for less than 3 days. I know that Colorado, for example, requires at least 4 days. That, I believe, is the highest number. But before asking for an employee sick leave, if they're taking sick leave, protected leave, you want to make sure you're complying with those requirements. And then we touched on this already, so I'm just going to kind of whiz over it. PTO policies, they often can be, most of these state laws say you are fine to cover this with PTO policies as long as the PTO is at least as generous as your sick leave requirements. But again, you want to make sure you're familiar with those sick leave requirements and making sure that your PTO policy applies to those part-timers and other employees that might not necessarily be excluded. I got a question come in. Are you required to pay out sick and PTO leave on an SEA contract? You are only required to pay out vacation, vested vacation on an SEA contract. You are not required to pay out sick leave. So there's no obligation to pay out sick leave, although you do have to carry it over year to year. And if an employee comes back into employment within a certain period of time, they have to be reinstated at their prior sick leave requirements. This is a quick slide about sick leave for government contractor employees. Not really the meat of this conversation, but just a reminder that there are sick leave requirements for government contractors specifically. These do not replace the state sick leave requirements, but they can be used towards those sick leave requirements. So if you have a policy that complies with the government contractor sick leave requirements, generally that will comply with most sick leave requirements. However, places like Montgomery County, Maryland include some additional requirements beyond what the sick leave executive order requires. We've also got a lot of difference among states based on restrictive covenants. For those who are paying attention to the FTC recent regulations, they are trying to restrict non-competes on a national level. We will see what happens there. That final rule has yet to be issued, but I think comments are due in the next month or so. So we're still going to wait and see what the FTC is going to do with this. But a lot of states within the last 4 years, I want to say, I lost track of time, but within the last 4 or 5 years, DC, Maryland, and Virginia have all applied exceptions for low-wage employees. DC, it's not really low wage. It's $150,000. If anyone earns less than $150,000 in DC, they cannot be subject to a non-compete. So you just want to make sure that any of your policies that are out there do create carve-outs for certain state requirements. There can be some penalties for trying to enforce an unenforceable non-compete against certain employees, so you want to make sure that you stay on top of that, not only because it's unenforceable, but because the law could ultimately penalize the company for trying to enforce something that's unlawful. Let's see. If work is performed remotely from an individual's home office, does the state sick leave of their residents apply? Yes, if they're performing work from the state where the sick leave applies, that sick leave rule applies. Remember that some states have a threshold on the number of employees. It's possible you don't hit that trigger if it's just one remote employee, but you want to double check. What I will do is I will reach out to folks who have asked questions directly, just so that I can get through the next couple slides. I have your questions here, and so I just want to make sure that I keep everything else in kind. One question that just happens to relate to the restrictive covenants. If you have a prime contractor that requires a non-compete, does the threshold still apply? Yes, it would still apply. So you might want to push back on your prime there and say, listen, we can't legally enforce our employees against this. There are also some state-specific requirements. There can be complete bans like in Oklahoma or California. There can be notice requirements like in Washington state. It really varies state to state. A lot of states prohibit non-competes for your non-exempt employees, but permit them for exempt. So whenever you're drafting these things and you want to consider where the employee is performing the work and the state-specific requirements. Non-competes are a little bit different from non-solicitation. Non-solicitation provisions prevent folks from soliciting your clients, whereas non-competes prevent folks from working for your competition. There can be some differences there, but sometimes if you can't do a non-compete, you might be able to do a non-solicit provision. And then lastly, if you have an overly broad non-compete provision, some states will fix it for you. The courts will say, okay, we know what you meant. We're going to just make some edits here. Other states will not. So it's really important, additionally, to know where the work's being performed in order to know what type of restrictions you might get away with and which ones you might not. And then lastly, we talked about marijuana legalization. I don't think I have to go into much more detail, just suffice it to say that 6 states currently limit an employer's ability to take adverse action based on a positive marijuana test. That means that if you do have drug testing and it's not required by a federal contract, you want to make sure that it's complying with state laws. As I mentioned, most of these states do have exceptions for federal contract work that requires drug testing, but not all of them. Like Montana, that sticky Montana, I cannot figure out where they're getting that law from. But just be extra careful in those states if you are denying employment based on a negative marijuana test. Some states prevent marijuana testing at all, and some just prevent an adverse action. So you want to make sure, if you don't fall within that government contracting exception, that it is compliant with state law. And then lastly, Drug-Free Workplace Act myths. It is a myth that the drug-free workplace requires drug testing. It is a myth that you have to terminate employees who test positive. But there are requirements that you keep federal contracting drug use off federal contracts. So if anything relates to performing work on the contract while intoxicated or while engaged in drug use, that certainly falls within the Drug-Free Workplace Act. If employees just happen to be engaging in drug use at home, maybe it's not great judgment, maybe it somehow impacts their work the next day, but technically if they're doing it off work, especially if it's marijuana, there might be some state law requirements that you want to keep in mind. What I will do is I will go over these last couple questions that just came in. If folks have other questions, I know we covered a lot today, but hopefully that kind of gave you a sense of where the climate is and what are some questions that are popping up lately in the government contracting space. But I'm happy and available to answer any questions after the webinar. I'll get to this next couple here for folks who are still on the line and want to hear, and then if others come in, please let me know. Sick leave is in addition to PTO, correct? In other words, you cannot incorporate it in a bundle. It depends. If you have sick leave, if you have SCA employees, no, it has to be in addition to your PTO. Other companies combine PTO or sick leave and vacation together, and it's fine. You just want to make sure that you're complying with those state-specific requirements if you're doing so. Our company contains overhead part-time employees, full-time overhead employees, contractual employees, and SCA contractual employees. That is a good complement. Our flexible PTO policy is only eligible to overhead, full-time, and contractual employees are in violation of PTO laws. So remember, there's no actual requirement to provide PTO, but there is a requirement to provide SCA employees with vacation and to provide certain employees with sick leave. So if you are operating in a state that requires sick leave and you do not provide other paid time off to those individuals, for example, if you don't provide your PTO to your, I just want to find the ones that aren't in here, to your non-contract folks who aren't overhead, then you could run into issues with sick leave. So you want to make sure you're complying with those sick leave requirements if you're in one of the states that requires it. And then lastly, if you offer PTO, sick and vacation rolled together and have staff in a state requiring sick, if the PTO is larger than the required sick leave, is that sufficient, or does it have to be tracked separately? That should be sufficient, but remember there are a lot of bells and whistles that go along with the sick leave requirements. So it's sufficient if you allow for sufficient carryover, if you allow for sufficient use and accrual. What I would recommend is that in your PTO policy, you specifically confirm that employees are allowed to use PTO for, the enumerated sick leave requirements that are protected by state law or the sick leave EO. I think that's everything. Thank you, everyone, for hanging in there. And thank you for joining. If you have other questions, please feel free to hit me up. And it was a pleasure answering all your questions today. Have a great afternoon. Bye.